ethics. There is a suit pending for dissolution of marriage under Section 13 HMA. My lords, there is one submission that I want to make, rather, in fact, two very short submissions here, because I believe that the judgment of this Honorable Court may directly have an impact on my ongoing litigations, my lords. My lords, HMA per se does not prohibit these kind of marriages, my lords. It neither renders this kind of marriage void nor voidable. And I'll quickly demonstrate that by reference to Section 5, my lords, if my lords could quickly have that, my lords.
Which act? Hindu Marriage Act.
Hindu Marriage Act, my lords.
Counsel, there is one concern here.
I don't think we'll go into this at all because you've consistently said.
My lords, I understand, but this is a case of not of same-sex marriage, my lord. This is a case where she has undergone the sex reassignment surgery.
Deal with individual cases like this, because
My
otherwise there'll
lord-
be infinite variations in individual cases.
My lords, the practical difficulty
No,
here
but-
is
but
that
ultimately that's why you're an intervener. We can't now sit down and look at interveners' facts in deciding a wider issue of constitutional jurisdiction.
my lords, I completely appreciate that. But my lord, just for a moment, if I could point out the contravention of Section 5(1) subclause 3,
See, this
which
is
is
all going to be case specific. And if we get into specifics of each case, then there's a Pandora box that'll open up. We can't go that far.
then, my lords, what I may submit, I'm not referring to personal law. Let me submit this. As per the Transgender Persons Act, now there are two categories which are recognized by the Act itself. One is a transgender person. The recognition given under law is that of transgender person. The second category under Section 7, my lords, is that of recognition as male or female. Now, once I've undergone the sex reassignment surgery, or those persons who may be called as transformed gender persons, my lords, because now they are conforming to the biological yardstick as well. So they may be entitled to equal protection under the law.
All right,
So
thank
that
you.
impact,
Yes,
my lord, may
Gupta.
consider while passing the
Mr.
judgment.
Gupta, what?
Yes, my lord,
yeah.
7 minutes. I will be less than that. My lord, I appear for, my lord, the queer collective of, my lord, the Indian Institute of Science, which is a protective body, my lord. Now, we have, my lord, our submissions are in volume 9 of your lordship's, my lord, compilations. And, my lord, a one-page note has been emailed today, my lord. You have copies? My lord, I can hand up 3 copies if your lordship so pleases now. I will only, my lord, address your lordship on 5 issues and I'll just state them. I won't argue, my lord. My lord, I have thought about this matter, my lord, on the basis of 2 questions: why and how. Why it is to be done and how it can be done. My lord, most of the submissions, 4 of these are, my lord, points on the issue of why. My lord, first of all, my lord, Section 4C of the Special Marriage Act appears to make a distinction between men and women as far as age is concerned. But this is no longer, my lord, a policy consideration, because, my lord, pursuant to your lordship's judgment in independent thought, the Child Marriage Bill has already been tabled, which, my lord, seeks to equalize the marriage age for men and women. So, my lord, there is a consensus that on the appropriate age of marriage. So the difference between these 2 categories, my lord, in the section is not a matter which should come in the way. That's number 1. Number 2, and this is very important, my lord, that persons of this, my lord, sexual orientation are being forced into marriages. And what is worse, my lord, heterosexual marriages. And what is worse, my lord, there are unscrupulous people out there who are suggesting that there can be conversion therapies, that it is medically capable of being corrected. Now, my lord, it has gone to such an extent, my lord, and I have got, my lord, a 1-page, my lord, opinion of the Indian Association of Clinical Psychologists, which I am handing up, my lord, where they have said that please do not get into, my lord, this question of conversion therapies. My lord, the point being, my lord, that if they are permitted to marry, they will be protected, my lord, against any forced marriages of the heterosexual nature, and they will not be subjected to any conversion therapies, my lord. So this is, my lord, a reason why. Thirdly, my lord, it is a misconception to say that family values that Indians cherish will be affected. Because, my lord, it is precisely for those so that they may enjoy and practice those family values that they wish to get married. All the values which we cherish as being, my lord, family values are, my lord, going to come into effect if they are permitted to marry, my lord. That's the third thing. The fourth aspect, my lord, is, of course, your lordship has heard it at length, and that is, my lord, that it is discriminatory per se to have a legislation which makes a distinction. Now, on that, my lord, in my note, and I'm not troubling your lordships further, paragraph 20 refers to, my lord, two judgments, one of South Africa and the other is of Canada, which says so, my lord, that if there is a legislation of relating to marriage and that legislation is discriminatory in the sense that it leaves out same-sex marriages, then I'm sorry, my lord, if it leaves out same-sex marriages, then it is discriminatory. Now, my lord, I come to the fifth aspect, my lord, that if the question of why is answered in favor of the petitioners, in that event, my lord, in order to prevent the invalidation of the legislation, my lord, it would be necessary to read it purposively. And, my lord, your lordships have already said that could involve adding, omitting, or substituting words, and that is AFCON's, my lord. My lord, those are my submissions.
Thank you, Mr. Gupta.
I may, I just need 1 minute.
May it please the court, my lord. I think I come next in the order of the
I'm
sequence that is
sorry.
given to your lordships. If the sequence is being followed.
It is to address the
Tulsi Raj, Miss Tulsi Raj.
Yes, I am. Yes,
Please.
I'll say.
obligation. I've prepared a brief note, my lord. I'll hand over a copy. Without repeating any of the points that's been already made, my lords, I think only two aspects of anti-discrimination theory that remained unexplored so far in the debates. The first aspect is, my lord, the concept of demeaning, which has been conceptualized by the scholar Deborah Hellman, and which your lordships will find on pages 3297 of volume 4 of the compilation on behalf of the petitioners. Ms. Hellman explains that every case of demeaning, my lords, every case of disrespect does not constitute wrongful discrimination. Scholars, my lord, your lordships are well aware, have always asked the question of what is in fact necessary in law for some act to be constituted wrongful discrimination. And she identifies two elements as important for an act to be identified as wrongful discrimination. The first is, my lord, that there should be an expression of unequal humanity of the other, that there should be an action that reflects that the other person is not treated as an equal moral person, and that is the first requirement. The second is that, my lord, the person who is discriminating, the discriminator, should be able to do that because of the social context. That is why, my lord, your lordships are aware, we have the whole concept of cognate and dominant groups in discrimination law, and it's always conceived that it is always a dominant group who is able to, or who is conceived by law to be able to discriminate against a cognate group because of the particular social context. Now, in this case, I would submit, my lord, that the exclusion of LGBTQ persons from the ambit of the Special Marriage Act would constitute demeaning in the way that scholar Hellman explains it. This is because, my lord, there cannot be a better example of demeaning rather than to say, my lord, that your love is incapable of being recognized by the law. There is no, my lord, no better example of demeaning rather than to say that your partnership is not deserving of legal recognition. Therefore, my lord, I would submit that the scholarly understanding of discrimination law, my lord, might help us to inform the reading of Articles 14 and 15, to inform our reading of the Equality Code of the Constitution. Now, the next point, my lord, is by referring to the theory of disgust by Martha Nussbaum, and your lordships have extensively made use of the scholarly literature by Nussbaum in various judgments. Now, my lord, the theory of disgust is propounded in the way that the approach towards same-sex couples or the approach towards LGBTQ in toto is grounded on a public disapproval, is grounded on certain prejudicial understandings of how these couples or how these persons conduct their lives. And your lordships will certainly appreciate, my lord, that the history of this is tracked, in fact, by Nussbaum in the American context by collecting statistical data relating to pamphlets which were spread during the whole debate on.
We'll have a look at that.
Yes, my
Will
lord.
be circulated. Then your next point is expressive harm and discrimination, which is based on Joseph Shine.
Which is based on Joseph Shine, my lord. I just want to make the point there, my lord, that when your lordships, my lord, struck down section 497 of the IPC, my lord, there was nothing in the provision expressly as it stood, my lord, which expressed any opinion about how what it conceives about the sexuality of women. But your lordships went ahead and said that there are certain prejudicial notions which inform this provision, and that is sufficient, and that prejudice is sufficient to render this provision unconstitutional.
The next point is about the proportionality test, which has been argued actually. We have just yesterday it was cited.
Yes, my lord, the proportionality.
That's all right. You
Yes.
cited modern day.
Yes, my lord, your lordships have dealt with proportionality, my lord, and
Then fourth is that your case is supported by data and that the respondents is.
yes, no, because, my lord, in paragraph 18 of the counter affidavit, my lord, the union says that there are psychological harms which are caused to the children of LGBT. That, my lord, is in fact rebutted continuously by data, my lord, and I have referred to one study, that is a British Medical Journal study on pages 3341 and 3358.
You are advocating a moderate interpretation, reading A as the in the SMA.
Yes, my lord. That is, in fact, a lot of suggestions have been put forward before your lordships, my lord, and it is, of course, up to your lords as to which interpretation will be taken, and that's a moderate and a minimally invasive provision.
Thank you.
I'm obliged.
My lords, if I may, I only wish to address.
What's your name?
My name is Tanushri Bhalla. I'm an intervener.
क्या नाम है? Manjushri Bhalla. Tanushri.
Sir, I only request to address the 4 questions placed by this honorable court before the petitioners.
Yes.
Your permission, please. Sir, I've submitted my written submissions and a brief note. If I may hand the same over to the bar, please. And literally. Bar, please.
So we also don't have this. It's being given physically to the.
Yes.
Yes,
My lords. Sir, the first question, Your Lordship, the first question addressed was on section 2B as to the reading of the terms man and woman. My only request is that it may be considered that there is also gender expression amongst parties who are seeking this kind of validation. There is gender expression, and then there is also the question of roles that may be assumed by parties to such marriage. If this concept, read in light of Arun Kumar and certain other data which I have put on record in my main IA, be taken into consideration, my lords, we may see that basically the problem in all the other sections remains solved. My humble suggestions are, my lords, that the man in 2B be read to include all 3, that is both cisgendered and transgendered men, as well as any person who assumes a role in the marriage that this statute confers upon men. And similarly for women, all 3, that is cisgendered, transgendered, and any person of either sex or gender assuming the role of a woman or a wife in that particular relationship may be conferred upon by the statute or by the society or by the institution of marriage. This will also remove the difficulty for trans persons, intersex persons who are not included in this ambit seeking to enter the institution of marriage laws. Accordingly, lists of prohibited relationships in part 1 and part 2 may be read to include any person, whether cis, trans, or otherwise, including but not limited to those identifying as third gender, so that both lists may apply uniformly and the difficulty with related to degrees of prohibited relationships may be removed. Thirdly, my lords may be pleased to direct the government to declare LGBTQI, which has already been done for the trans community, as a special class, as they are allowed to do so for customs, so that where personal customs of parties allow them to get married and enter such institution, there may be no difficulty for them to do so. We are not touching upon personal customs, but where they are allowed by personal customs, where families are supportive, they should not be hindered just on basis of a technicality. My second point, with your permission, is section 4C, which was the consequence of section 2B, as pointed out by Honorable Justice Butt, that it has already been pointed out by learned senior Vishwanathan sir that the section may confer 2 males and 2 females of age 21 and 18 respectively to enter matrimony. However, what I request to add, sir, is that this provision leaves out third gender persons who may be intersex persons and who may be left out of the binary of male and female. For that, I request, my lords, make kindly read an age into the section for third gender persons not conforming to either male, female, or the role of a man or woman based on self identification, such as intersex persons. So, and also any other affected person on the remaining spectrum may be addressed by this particular reading. And this may also be relied upon section 15D of the Act, Malos, where the age is uniform for any parties as 21 seeking to register their marriage among, within the Act without leaving any lacuna for external controversy or any external violations. Malos, my next point, which is extremely important and which I request to add before this honorable court, is based on section 24(2). My lords, this is the section for void marriages on grounds of impotence. Now, in practical cases, it has been seen that unscrupulous people enter into such marriage with trans persons, and when disputes arise, as in the case of intervener Bobby Darling, they seek the shelter of law, stating that the marriage was void ab initio because of the ground of impotence, or that they did not know. Herein, if my lords may please to declare or add as an explanation in any way that these marriages would be void except when knowledge of such impotence was communicated prior to the marriage uh, to both the parties by either a visibly obvious way or in an express manner, basically prior to the marriage, or where the parties, after discovery of such fact, have continued to cohabit, condone, and live with each other in harmony for at least 1 year after the discovery, then this particular law, which is being misused by unscrupulous persons, can be addressed, and this will greatly reduce litigation, Malos, current litigation.
All right.
And Malos, lastly, I will just conclude in under 1 minute. If we read gender expressions and accept the roles assumed by parties into this act during interpretation and harmonious interpretation, Malos, all the remaining sections and all the remaining difficulties will stand resolved, as in third, fourth, and fifth schedules. It's on para 6 of my brief notes, Malos, wherein declaration may be by either 2 brides or wives, or 2 bridegrooms or husbands, or a bride and a bridegroom of either biological sex expressing or assuming the role as per the marriage. Sections 12, 22, and 27, where it mentions either husband or wife, it does not mandate.
All right, we'll have a look at
That's,
that. Thank you.
Thank you,
Thank
Malos.
you very much. We'll rise, I think, now because we wish 5 minutes. Mr. Solicitor, we'll hear you after lunch.
Look, there was a matter, wherein AD Gayatri had said that she may join.
Morning, Brother Bhatt.
Morning to you. Morning.
My lords, my lady.
Paul, yesterday, I said that we will break so that you have a little time for your. Yourself to just stretch, and we just got lost in work, and then at 12:30 I asked you. So what we'll do is, we are anticipating that by 12 o'clock we'll be completed with the arguments of this side. So at 12 o'clock we'll take just a break for 5 minutes so that Brother Paul also can just stretch around a little bit.
Thank you. Thank you.
If you feel that you have to take a little break earlier to just stretch, please just tell us. We'll immediately take a break.
Seems I'm doing fine to that limited extent. Okay.
Perfect. Yes, Ms. Nandi.
My lords, my lady. Brief note. It's not one page.
I wanted to appeal to all the members of the bar that now that we are dealing with CBs, all my colleagues and I, as judges, we feel that there should be some cutoff beyond which every morning we can't have 600 MB files and huge papers being filed every morning. Then even for the other side, then it becomes very difficult for them to anticipate what they have to prepare.
Absolutely.
So we must have a cutoff when the arguments start. Then thereafter, if something exceptional, one wants to file a short note or something, that's different. A 2-page, 3-page note, but. Basic material shouldn't come in, every time, every day of the hearing. All right, but we'll set up that protocol. Yes, Ms. Nandi.
My lords, I filed a 3-page note.
Yes.
We didn't keep it to 1 page, my lords, though we could have, only because for the convenience of your lordships, we wanted to reproduce the paragraphs that we are referring to rather than jump between.
So, Ms. Nandi, what are the submissions? Can you formulate your points?
Yes, my lords. My lords, I seek a declaration that includes my rights as queer, non-heterosexual, and same-sex people to marry under the secular legislations, the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders only under the Citizenship Act. My lords, I will briefly go through what I will be covering and then go to the last point first. Number 1, Special Marriage Act deals with...
Volume 7, hai kya? Is this tabulated form? Even I have a tabulated. Submissions dated 26
all I have.
23.
Two tabulated forms. One is
No, there's just this one form, my lords.
Both justice. Both justice.
The cover page is 1 page. The submissions are 3
I got the
pages.
same thing.
Summary of arguments.
That's 3 pages, right?
It's 3 pages.
Summary of arguments.
The cover page is 1 page, so the PDF may be showing 4, but it's in bullet points. We all have our preferences, my lord.
Yes,
It fell from my
Brother
lord's
Paul,
hand.
Brother Bhatt, you have those 3-page submissions?
I have a 6 or 7 page, 6 or 7. I don't know.
It says submissions dated 26/4/2023, correct?
Yes, my lord.
Yes.
the 12-pager and
It will be in compilation 1, volume 7, my lord Justice Bhatt.
Yes, volume 7.
My lord Justice Call has it.
I have it.
Ravi, do you have it? Brother Bhatt, do you have it?
I don't know whether I have volume 7.
It was.
It says submissions dated 26/4/23, 2023. ये renumber किसने किया है actually?
It's a table, my lords.
Yes,
No.
It's a table with bullet points.
217 KB.
Why don't you email it to Justice Bhatt? Brother Bhatt, the court
Really,
martial will just email it to you.
Where is it? Is it in liquid text? Now you've given.
justice, but I have mailed it to you.
Okay. Yeah. Yes, we are. I have.
Got it? Okay.
Yes,
We're
yes.
grateful, my lords.
All right.
So, my lords, I am seeking a declaration that includes my rights as queer, non-heterosexual, and same-sex people to marry under the secular legislations, the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders under the Citizenship Act that constitute a self-contained part to grant entitlements based on registration, recognition of foreign marriages. My lords, I will briefly describe the first two sets of points and then deal with the third first, because nobody has
Now
dealt
let's
with
see
the
the
third
summary of submissions.
yet. I beg your pardon, my lord?
Let's go through the summary of submissions now.
Yes, my lords. First, my lords, under the Special Marriage Act, it has been submitted that 99.9% of people fall in the gender binary and are men or women, whether they are queer or trans or straight. My lords, we adopt the other arguments of Dr. Singhvi, but my lords, on this point, we differ. The 2011 census itself showed that there are at least 4.8 million, and this is a huge underestimate, my lords, of trans people in this country. Many of them, my lords, are in this courtroom, and I mention this because of the way that they have been demonized in the public. Ms. Muskan Tibrewala, who has rendered excellent assistance, is one such person who is going through a coming out space and has given this permission to
Your
me.
first point is you have referred to section 3 and section 2K.
Yes, my lords.
The 3 speaks of non-discrimination against non-binary persons. That's fair enough.
Yes.
Then the next point which you were saying, that is, just explain that. You say that rule 5 of the transgender rules already recognizes marriage of trans persons. What is can you read out the rule for
My
a
lords,
second?
there are the rule.
Is a rule in that book?
Can I have the rule?
Sure, I see.
Rule is in the
Rule
book. Can I have rule 5?
Yes, it is. Rule is there.
Where is it? It's not 3 pages. No.
Yes, here it is.
Rule 5, right?
Yes, my lords. My lords, rule 5 refers to the application for certificate of identity. Do my lords have it?
Yes, we do.
No, but rule 5 says issue of certificate of identity, right?
What? 6 is issue of certificate of identity, my lord.
No, 5.
5.
Take time to download.
We have the 2023 Act, my lord.
No, we have a 2020 rules.
I mean, we have the 2023.
Same rules.
Yeah,
Rules have changed.
2020 rules.
If you're saying that 23.
I beg your pardon, my lord.
Rules are 2020, right?
Issue of certificate of identity for a transgender person under section 6.
No. 6 is procedure for issue of a certificate of identity. 5 is issue of certificate of identity. Right?
Yes, ma'am.
Which one are you looking at? 5 or 6?
My lady, under these two rules, a certificate of identity is issued to trans people.
Yes.
In that regard, an affidavit is required to be submitted, and the form of that affidavit is provided in the rules itself. So it is the forms that I am on more than the rules. The rule is the power to issue the form, and I am now on the form.
But when you say rule 5 already recognizes marriage of trans persons, where do we get that from? Because that's an important point.
My lord, it's more that the form acknowledges.
Where is the form? Which page is the form?
Form is at page 3224.
No, it's here also in the
Form
number.
Justice, in page 17 of this act, if you have it.
The form is at
Actually,
Form
Justice,
5.
I think let us focus on page 17 of the act.
I beg your pardon? Oh. I'm sorry, my lord Justice. I can't see the judge.
You have the enactment, so you can see the act. Page 17 contains the form.
Yes, that's what it is. Form 1.
Right.
Yes, form 1.
2D, 3.1 and 6.1. We suppose this is the form you are relying upon to say that
The next
it
page, my
recognizes
lords,
the
is Form 2. I have page 19. I have the 2023 Act.
That's fine.
It's a
23 Act.
What
There's
is
no
this
23 Act.
23 version.
2019 Act.
2023 version.
Yeah.
It is the 2019 Act.
Right.
But because I'm referring to page numbers, this is the version that I have.
Form 2.
Form 2. Form 2, do my lords have it? It says,
We do.
I, the form of affidavit to be submitted by a person applying for certificate of identity for transgender persons under Rule 4 of the Transgender Persons Protections Act Rules 2020, read with Section 6 of the Transgender Persons
Most
Protection of
important is
Rights
I
Act.
perceive myself as a transgender person whose gender does not match with the gender assigned at birth.
Yes, my lords. I declare myself as transgender.
Right.
But the top part says, I, so-and-so, son/daughter/ward/spouse of.
Right. A person who is already in a marital relationship
Yes.
can therefore seek a gender reassignment, like
Or
by
a
virtue of form.
self-declared identification, precisely what has fallen from my lords. Indeed, as my lords Justice Bhatt has said, some people may seek a divorce pursuant to this. Many people in our society will not. And there is no bar in this regard in the Act, and the Act is
So
silent.
it already recognizes the, say, a pre-existing marriage of a person who is trans.
My lords, the pre-existing marriage, but also the subsisting marriage. Because when
Right,
they
right.
transition and after they transition, it continues to subsist.
Correct. There is no bar in law.
Right.
Then there is no bar in law.
Somebody who seeks to assert their identity as trans
Yes.
may well be in a marital relationship at the
Precisely.
point of time when they assert that identity.
Yes. But they also continue to be in that relationship.
Right.
And that relationship under law is not dissolved or annulled or taken away from them.
Yes.
The law accommodates it because these are not grounds for nullity or divorce by the other spouse, because
I'm grateful, my lords. That's exactly our point. My lords, there is another mention of this in Form 6. And the illustrative list of documents on the next page includes a marriage certificate at item 12.
No, this applies only for both this and Form 2 will apply to married people who seek that identity as transgenders.
Precisely, my lord.
Right? These forms accommodate such people.
Yes, my lord.
The rule makers have contemplated situations where people seek this gender role, or rather regender themselves, if one could use that expression.
Yes, my
To
lord.
that they recognize and acknowledge that there could be pre-existing marriages.
Yes, my lord.
Mr. Nandi, is it your case that because the rules recognize the concept of a pre-existing marriage in such a scenario, that itself amounts to a permission to have a marriage after such change? Is that what you are seeking to? So, see, there's a pre-existing relationship which will continue. As Justice Bhatt said, it may not dissolve because there may be many ramifications which may arise from such declaring the marriage a nullity or something. So it accommodates that viewpoint. But does that imply that after change, if suppose you are unmarried and there is a change, you can marry? Is that what you are trying to say?
No, that would be my set of arguments that I have made in my larger written submissions, my lords, on constitutionality and harmonization. But my lords, that is precisely right. What I am saying right at this point is that the state already recognizes through delegated legislation and the forms that have been issued under that delegated legislation, some trans marriages, and that some at the moment is restricted to marriages that were pre-existing prior to my declaration of identity
Be clear
to
that
transition
ma-
biologically.
the marriage recognition is
Yes, my
between
lords.
the marriage was solemnized at a time when both parties were not trans. Neither of them were trans.
True. But it subsists because
Let,
there is no bar-in-law as had fallen from my lords.
let me come. Perhaps there is no ground for divorce in marriage laws. Therefore, there is a recognition of the fact that once somebody finds himself in this situation, we will not disturb it. Because once you start disturbing, there could be other consequence. So you recognize that situation.
Yes,
That
my
is
lords.
one thing to accommodate in the form of rules or even forms. Now we are not talking about rules, we are looking at forms.
Yes, my lords.
If we are to transform that into substantive provision and work backwards, as it were, there should be some statutory support for that.
Yes, my lords.
Because unless you state that, for instance, Section 3 or whichever provision says there shall be no discrimination, and then goes on to say in what aspects, like you have
You
in
can
Section
still continue
47
to be
of
married.
Disabilities Act. So
Yes,
what
my
are the rights and what are the obligations, what rights of these persons who claim these identities, and what are the obligations of society? The legal obligations are also spelled out. So if your argument is built around these forms, then you'll have to go further.
My lords, the argument is precisely the way that had fallen from my lords, Justice Bhatt. We have said, for example, that it has been said in this court, during these proceedings, that trans and non-binary people are elite, that small portion, etc. My lords, the first point addresses that. The second point is on the non-discrimination, my lords.
The elite argument you can just keep aside because we are now going into the core constitutional issues and core statutory issues.
Yes, my lords.
So, elite is a matter of prejudice. I mean, but it has no bearing on how we decide the matter.
I'm grateful. Let's
Actually, these two forms which you showed us, the first form, Form 2, is at the stage when you apply for a gender identity certificate.
Yes, my lord.
Form 6 is after a gender as reassignment takes place. Because if you see Rule 7.4,
with the ID.
Form 6 is to be read with Rule 7.4 because that's that's in the title of Form 6. And 7.4 says the district magistrate, while issuing the certificate of identity for change of gender, shall simultaneously issue an identity card in Form 6 to the applicant.
Yes, my lord.
And that form in item 12 refers to marriage certificate. So these two forms seem to indicate that both when a person applies for a gender certificate in Form 2 and the issuance of a reassignment in certificate in Form 6, they do contemplate that somebody could be a party to a valid marriage because or a subsisting marriage.
The
Precisely.
position as it existed at the time of the grant of the certificate is what is contemplated, without anything more.
But also, as my lord, the Chief Justice had pointed out, that after the gender reassignment surgery is done, the situation is different. And then,
No, but Ms. Nandi, if you see the Act also,
yes, my lady.
Section
Yes,
5, 6, they refer to application for certificate of identity. They refer to issuance of certificate. 7 talks of change in gender and specifically says that it is, if you will read that an application may be made along with the details of the institution where the person has undergone surgery. So the whole idea is so that the certificate can be revised. The context is of 4, 5, and 6 is issuance of certificate of identity.
Yes,
In the course of that,
Yes.
The status of that person, as it were, is reflected from one of the columns, but that's about it. So how do you propose to take it further?
My lady, the
Build
point
your
is
argument.
this. My lady, what I am saying is this, is that the law recognizes under Section 2K the range of gender identity. In Section 3, if we may come to that, (3)(e) specifically,
Yes, please.
prohibition against discrimination, 3E says the denial or discontinuation of or unfair treatment with regard to access to or provision or enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or opportunity dedicated to the use of general public or customarily available to the general public. So it's a broad non-discrimination provision. In addition, and this is my third point, that this is not happenstance.
You're right, it's not happenstance.
Because of Nalsa, my lady.
But then this is a right which is available under 15.2 to some extent.
Precisely, I'm grateful to my
Don't need,
Lord's Justice, but this is
don't need a NALSA. 15.2 encapsulates that. It's a wide horizontal right, right? So, I mean, to take your logic, let us go to Rule 5. Rule 5 talks of issue of certificate of identity. Right? It says the certificate, number 3, sub-rule 3, certificate of identity issued under sub-rule 1 shall be the basis of change of gender as well as the name and photograph if so necessitated in all such official documents as provided in Annexure 1. Yes. Now, what is Annexure 1? We don't have that in this.
Annexure 1 is perhaps what is at page 23. It refers to Annexure 1, brother. Card issue date, signature of Annexure 1's illustrative list of official documents referred to in the name of the official document.
it's titled Annexure 1, as my lady has pointed out, above the table.
Page 23.
It is Annexure 1.
No, it's not.
It's a part of Annexure 1.
Annexure 1 is not part of
No.
Form 6, it's an independent annexure. And this is something relatable to Rule 5.
Yes.
So, just to take the thought further, Ms. Nandi, not
Yes,
everyone has a marriage certificate. Not everyone has a marriage certificate.
Yes, my lord.
You agree?
Yes, my lords. Not everybody has a marriage certificate. Some transgender marriages continue to subsist.
No, I'm not talking of that. I'm talking generally.
Yes, my lords.
Matrimonial.
Yes, not everyone has a marriage certificate.
Because marriage certificate is a civil kind of form which is not mandated by any personal law. There is no compulsion except maybe in some states.
Absolutely.
Certificate. The only certificate which is mandated is under the Special Marriage Act, because that is the only form of marriage between those two classes of persons who belong to different communities, right? So a marriage certificate itself might pose a problem for anyone.
Yes, my lords.
Yes.
My lords, I am only pointing out the current situation. I'm pointing out that currently that there are some transgender marriages that at the point of transition are recognized to subsist. There are other transgender marriages that are not. Either they do not have the marriage certificate, or they cannot marry the person they love only because of the timing. That is my point, my lords.
See, that point is, I mean, you have made your point, but the point, there is a distinction, which is that those who are married as not transsexuals, as heterosexual couples, a a heteronormative based marriage, so to say, later turns out to be one where one recognizes her gender not as a female or male, but as a transgender person. At that stage, the law enables this much, and it also does not upset the pre-existing.
Yes, my lord.
Exactly.
Now your dilemma is the next step, which is that having recognized the pre-existing relationship, you have not enabled two transgender persons to come together and celebrate their union in
Yes.
matrimony. That is your dilemma.
Yes, my lord.
Where you're saying, no, you can't locate that within the enactment.
Yes.
To the
We are
extent
not.
that
We
the
are
law
not.
recognizes this,
Purpose of
but you have to go beyond that, and there you have to fall back on the same arguments which are made by your predecessors.
By many counsel before me and by me, but I will not repeat them in the interests of brevity, my lords. But that is precisely, my lords, what our burden is, to discharge the burden of constitutionality as it relates to the argument that goes beyond the forms. And my written submissions, my longer written submissions, which is in compilation 1, address all of those arguments as well, my lords.
What is the next point?
The next point, my lords, is just to say that this is not happenstance, that the Transgender Act of the Union, not so long ago, only 4 years ago, was enacted pursuant to NALSA. And what NALSA says at para 119, and I've reproduced the part for convenience, that therefore gender identity becomes a very essential component which is required for enjoying civil rights by this community, viz. the right to vote, the right to own property, the right to marry. On workability, my lords, on workability, I have worked it out, and my respectful submission is that there are only two doctrinal principles that need to be applied for a minimal reading in. The first is this, that husband and wife should not be collapsed into the same category, my lord. And there should not be one gender-neutral category of spouse. Because the heightened protections that are given to women emerging from Article 15.3 are there for a reason. So what we have proposed in this note, but the reason we didn't file it because we would like to hear what the other side has to say. But this is the current formulation. Is that third gender spouse, which is a phrase used in NALSA, it has been critiqued. So non-binary can also be used in this regard, may be used along with husband or wife. And of course, husband or wife must include trans husband or wife. As the Madras High Court did for the Hindu Marriage Act in Arun Kumar, that judgment is in my compilation. I'm not going into it because it's the Hindu Marriage Act. But that's the way the Madras High Court had worked it out. The second doctrinal principle, my lords, is this, that
can you send this on email to the court master so that he can then email it to justice?
we will do it in the next 10 seconds. We weren't planning to hand it over, my lords, but...
So you are saying, I'm sorry, Ms. Nandi, there was a lag here. I think perhaps Justice Call also.
Yes, my lord. Shall I repeat what I said, my lord?
First you said that you do not want a neutral phrase like spouse. You don't want to collapse the gender.
Basically,
Because
the Bhatt and Justice Call.
Yes.
What Ms. Nandi's tabulated statement, the tabulated statement which she has given us now,
yes,
seeks to interpose the word or third gender person in various provisions of the Act, including Section 2B. So, for instance, in 2B, she says a man or third gender person. Likewise, a woman or third gender person. In Section 4, which deals with conditions relating to solemnization of special marriages, the male has completed the age of 21 years and the female or third gender person, the age of 18 years. Likewise, in Section 12, I so-and-so take B to be my lawful wife or husband or third gender person. So, then spouses instead of husband and wife. In Section 20, in 15, husband or wife or third gender spouse in Section 22.
So I think it goes on then.
That goes on, exactly.
So
Just to emphasize, my lords, that I used third gender because it comes from Nalsa and it has precedent in law. But it has been critiqued by the communities. And so non-binary would serve just as well. Non-binary person or non-binary spouse.
Ms. Nandi, so then you
Lord.
comment that the approach of the Madras High Court should be adopted in regard to all this. We understand that. The only question is, where do you perceive the conflict between your position and the position by the predecessor council? Because that is something we have to iron out.
Yes, my lords. My lords, the Madras High Court supports this workability note only to the extent that man or woman includes trans man and trans woman. What we have added here, my lords, is non-binary persons based on two doctrines: differential protection for women to be preserved, and that heightened protection also be provided to non-binary transgender persons due to the fact that in line with Article 15.2 to 15.4, NALSA requires the union to provide special provisions for transgenders and affirmative action as social and economic backward classes. So there is a ground because of historic discrimination in para 67 and 68. Read out the paras. This is at volume 1. Shall I come to that, Manu?
Yes.
This is volume 1, compilation 4, PDF 792, and paperbook para 761. I'm on para 67. Transgenders have been systematically denied the rights under Article 15.2, that is not to be subjected to any disability, liability, restriction or condition in regard to access to public places. Transgenders have also not been afforded special provisions envisaged, and my lords may note envisaged already, under Article 15.4 for the advancement of the socially and educationally backward classes, SEBC, of citizens, which they are, and hence legally entitled and eligible to get the benefits of SEBC. State is bound to take some affirmative action for their advancement, so the injustice done to them for centuries would be remedied. Transgenders are also entitled to enjoy economic, social, cultural, and political rights without discrimination, because forms of discrimination on the ground of gender are violative of fundamental freedoms and human rights. Transgenders have also been denied rights under Article.
All right, Ms. Nandi, we've seen Talsa. Now, should we go back to your statement actually, so that that's page 2, so
Yes,
that we can just look at it and then we can wrap up, I think.
My lords, I have 2 additional points, if I may, and my third point is one that nobody else is raising.
Yes.
So I'll go through this very fast and then come to my third point.
Yes.
So 15.2 to 15.4, my lords.
Where are you reading?
Differential.
Where are you reading in your
Part of the statement are you on?
which page? Which page of your statement?
I finished page 1 and I am turning to page 2 to deal with the Foreign Marriage Act.
Yes. Okay.
My lords,
Submission
should this
26
court
26.
only read the Special Marriage Act inclusively, an immediate Article 14 anomaly will arise. The statement of objects and reasons in the Foreign Marriage Act explicitly and repeatedly states that the FMA is pari materia to the SMA and incorporates provisions of the SMA by reference. So the FMA applies when one party is an Indian citizen and the marriage is solemnized outside India. So for clarity, it doesn't apply to two foreigners. However, the same Indian foreign couple may come to India to marry under the Special Marriage Act because the judgment that I have placed on record, and I've only placed one, it is of 2023 by Justice Pratibha Singh, and she has detailed the other case law that also says the same thing. And it holds that even two foreigners, male and female, can marry under the Special Marriage Act because Section 4 uses the term any two persons and not citizens. So if the Foreign Marriage Act does not follow the Special Marriage Act in being read in a gender-inclusive manner, same-sex, queer, and transgender couples may marry in India, my lords may scratch out or at a consulate, may marry in India, but if they are already married on foreign soil, they will not be able to have their marriage registered by an Indian marriage officer under the Foreign Marriage Act, Section 17. The reason is that 17 refers back to Section 4. And Section 4 is the only place where gender-specific terms bride and bridegroom have been used. And we have done this workability exercise, my lords, and placed the Foreign Marriage Act provisions also under the table that we have submitted to my lords. We will refine it if required, if there are submissions in this regard from the other side. But my lords, the rest of the Act, if Section 4 is read inclusively and in accordance with a declaration or the Special Marriage Act, falls almost automatically into place.
So then now your final point, which is
My final point is that there is a third category of persons. And this third category of persons are represented only in my petition. They are left in a catch-22 situation. We are married OCI persons with families who choose to live here. Some of us, and some who have deep roots in this country. Many have been Indian and then moved abroad and become OCI. They cannot marry under the Special Marriage Act because the third schedule requires a declaration that one is not married. They cannot marry under the Foreign Marriage Act because that only applies to an Indian citizen marrying a foreign citizen.
Who is there before us of that category?
So before you, my lords, are Kamakshi Raghavan and Melissa Ferrier.
Want to see if any of those people fall in the category that you are mentioning.
Yes, my lords. My lords, if I may have the leave of the court to say a little bit about Kamakshi Raghavan and Melissa Ferrier.
You said that they cannot marry under the SMA because the third schedule applies to persons who are not married.
Yes.
And they cannot marry under the FMA because?
One party must be Indian and one party must be foreign. Here, my petitioners, one party is OCI and a foreign citizen, and the other party is foreign. And if I may tell, as had fallen from my Lord Justice Bhatt, just a little about Kamakshi and Melissa.
Yes, we can. Can we decide constitutional validity on individual cases? You know, I mean, validity of a provision doesn't become suspect because of, it causes injustice in individual cases. You have to look at the constitutional validity of a provision from the larger perspective.
Shall we look at the plain words of the provision? my lords. But first, if I may tell my lords a little bit about this couple.
See, we have.
With my Lord Justice Bhatt's permission, if I have
Miss-
time in the end, shall I do that? And shall we go to the section itself?
Classical statement of law was by Justice Krishna in R.S. Joshi versus Ajit Mills that you know.
My lords, I am on constitutionality. Hardship is only a supportive argument. And constitutionality.
My question was not an invitation to outline the facts, because when we are deciding, none of the previous council have outlined any facts except the barest minimum. Because if we are to, then we would delegate this matter somewhere else. So tell us how this, the only thing, one sentence, how is it relevant or is it not in your petition? If it is not, it is moot. Why should we decide it? If it is, then you say so and proceed. That's all.
So why don't you summarize now, as we are concluding, give us the core of your submission. Why don't you summarize it now so that we can then note it and then we'll conclude.
Let me summarize my submission with regard to the Citizenship Act. As had fallen from this honorable court and from Justice Bhatt in particular, that is there a segregable provision with no prohibition in the enactment in which certain things which can be done straight away without entering other arenas in enactments where there is no express prohibition of the remedies sought. I have reproduced section 7A1D of the registration of overseas citizens of India card holder in the note itself. My lord, we have also requested the courtmaster to keep the act ready. The provision is clear. If I may read it briefly. Registration of overseas citizen of India card holder, the spouse of foreign origin of a citizen of India. This would, or if my lords find in my favor in the Foreign Marriage Act, this would automatically be recognized. Or spouse of foreign origin of an overseas citizen of India card holder, registered under Section 7A and whose marriage has been registered and subsisted for a continuous period of not less than 2 years, immediately preceding the presentation of the application under this section. 2 requirements, therefore. 1, that there be a valid marriage in another jurisdiction, and 2, that it be subsist for 2 years. And then subsequently, provided that for the eligibility for registration as an overseas citizen of India card holder, such spouse shall be subjected to prior security clearance by a competent authority in India, and provided further that no person who either of whose parents or grandparents or great-grandparents is or has been a citizen of Pakistan, Bangladesh, or such other country as the central government may, by notification in the official gazette, specify shall be eligible for registration as an overseas citizen of India cardholder under this section. There is case law, very briefly, my lord.
Consider Section 7A, yes. You've extracted it here, we'll see. All right,
my lord, if I may just have 1 minute
yes.
to point out the case law that already exists. There are a variety of high courts have found that nothing can be read into this provision. In Nadidi Eze, he was an illegal immigrant and they said there is no bar in this particular section. Etc. In Yossi bin Ari's case in Israel, they said that the registration official is not competent to determine whether there is a legal or social framework.
Nandi, thank you. Yeah, yes, now we'll hear.
I'm extremely grateful, ma'am.
I'll get right to it, my lord. Your lordships had raised certain questions yesterday. My endeavor and my time will be only to address those questions. Whatever points I've raised in my submissions earlier are already there with your lordships. I had also circulated, I should say, an additional note this morning. It's the note dated 26/4/2023 in response to queries raised by this honorable court during the hearing of yesterday's date. Do my lords, it's volume 10 of the folder titled Written Submissions. That's the first folder.
Yes.
Do my lords Justice Bhatt and Justice Kaul have it?
Yes, I've got it.
I'm most obliged. I'm most obliged. As I understood the proceedings, can I have one?
Where is it separate? Don't download it again. Just check it.
While my Lord Justice Kohli's laptop is being uploaded, can I just summarize what I've understood?
Please go ahead.
Please, my Lord, I'm obliged.
Yes, please. Okay.
My Lords. As far as the constitutional issues were concerned, those were clearly set out before my Lords, Article 14, 15, 19, 21, etc. The case law is also clear before my Lords. There was then a question of interpretation of the statute. Now, there are various provisions of statutory interpretation in my Lordship's arsenal, both the principle of updating construction as to how to read, reading up, reading down, and so on. The question which I understood falls from my Lords is how far my Lords will go in their interpretation of the statute. At the heart, there are certain provisions of the SMA. So we left out personal law in terms of the Hindu Marriage Act altogether. At the core, there were certain provisions of the SMA, Section 2, Section 4, Section 27, 36, 37, and so on, which were read by my learned friend, Dr. Singhvi. And there, the proposition that broadly has emerged is that my lords can read the words husband and wife, bride, bridegroom, etc., insofar as they occur in this statute, either in a gender neutral manner or by reading in the word spouse. So the general proposition then is that there is an act of reading in, an act of expansion of the statute to include a hitherto excluded class, which both updates the statute in terms of present day reading and understanding of relationships, and secondly, brings it in tune with our current understanding of the Constitution. Now, my Lord, the questions which fell from your Lordships yesterday pertain to, firstly, Section 21A of the Special Marriage Act, which I've sought to address in this note I've now submitted. And the question that follows is, to what extent do my Lords then retain personal law for LGBTQ couples who may marry under this statute, who may be similarly placed to other couples, that is, opposite sex Hindu couples, to which Section 21A applies? That is the first question which your Lordships raised yesterday and which I believe is troubling your Lordships. The second question is a more general question, that when we look at general civil statutes that relate to the rights, what we are so far calling the rights and obligations of marriage, to what extent will those apply to LGBTQ couples who marry under the Special Marriage Act? So we are confined, my Lord, to the Special Marriage Act. But the question is, what are the consequences of the interpretation that would follow if your Lordships were to decide in favor of the petitioners? Now, I will take my Lords through my reasoning as set out here for both the first and the second question, but the conclusion I'll come to is this, that your Lordships cannot decide every question today. The statutes, whether we talk of gratuity, as my Lords did yesterday, pension, there are any number of benefits that and obligations that flow for married couples, or whether we speak of the consequences of 21A, these, my Lords, are complex statutes, and LGBTQ couples, as it fell from my Lord Justice call on day one, LGBTQ couples will come to your Lordships, and more importantly, in fact, to the courts below, to family courts, to civil courts, and to the high courts, with questions of statutory interpretations as they raise claims and they seek the protection of law in the same manner as opposite sex couples do and have done now, perhaps since the codification began of matrimonial laws starting from the early 1800s onwards. So we are no different in that regard. In fact, if I may say, what we ask for today is the right to not be different, that our differences stand ameliorated by our inclusion under this one statute. So what your lordships have said so far is that the application of the Special Marriage Act would be expanded, and then it would apply to us as it does to all other couples. That, my lord, is my submission, would continue to be the reading for 21A and for other general civil laws. And what I would submit, my lord, is that a declaration, both a positive declaration in the form of mandamus and a negative declaration in the form of prohibition, would go a long way in easing the work of the courts below in the interpretation of the statutes, as they must now commence doing in the work that they will have to come. If my lord will see, I have set out that declaration at the very beginning of the note. It is first, my lord, do my lords have it? In paragraph 3.
Paragraph 3. Yes.
My lords have it? Justice Kaul and Justice Bhatt?
Yes.
I'm obliged. I'm obliged. So we seek, my lord, first the positive declaration that a marriage solemnized or registered, it would be solemnized, I apologize. Marriage solemnized under the SMA 54 and the parties to the said marriage shall be entitled to all the rights and obligations conferred on a married couple or a party to such marriage under any other state or central law, notwithstanding the gender identity and sexual orientation of the couple. And your lordships would also, I propose, give a negative declaration binding the state, that the state nor any authority of the state shall deny rights and obligations conferred on a married couple or such party, and then the formulation is the same, under the Special Marriage Act only on the grounds of sexual orientation or gender identity.
Yes.
With this groundwork in place, my lords, I'll now come to the first question which fell from your lordships yesterday. And my lords, let me say, it is not a light question. It is not a question to be easily decided. It is not a light question for us to consider either, to contemplate. As far as Section 21A is concerned, I would first submit that on a statutory reading, in terms of the application of the principles of statutory interpretation, which your lordships will consider, 21A will apply to same-sex or LGBTQ married couples who marry under the SMA in the same manner and with the same force as it would apply to an opposite-sex couple. Now, for my lord's convenience, I have actually set out the section in the note itself, but we can take it from the statute as your lordships prefer. May I read for your lordship's benefit? It's, my lord, at page 5 of my note. There's a table set out, but otherwise, if my lords have it, I'll just go ahead. Special provision in certain cases. Where the marriage is solemnized under this act of any person who professes the Hindu, Buddhist, Sikh or Jain religion with a person who professes the Hindu, Buddhist, Sikh or Jain religion, section 19 and 21 shall not apply, and so much of section 20 as creates a disability shall also not apply. Now, my lord, let's read the chapter starting from section 19. Section 19, my lords, the marriage solemnized under this act of any member of an undivided an undivided family who professes the Hindu, Buddhist, Sikh or Jaina religions shall be deemed to effect his severance from such family. And let me say, my lords, that the membership of such a family is not something which we take lightly. It is an important part, my lord, of the way in which we see ourselves as members of the family and as society. But, my lord, section 20, subject to the provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to the same disabilities in regard to the right of succession to any property as a person to whom the Caste Disabilities Removal Act 1850 applies. I'll take my lordship to the Caste Disabilities Removal Act also. Section 21, succession to properties married under properties of persons married under the Act. Notwithstanding any restrictions contained in the Indian Succession Act with respect of its application to members of certain communities, succession to the property of any person whose marriage is solemnized under this Act, and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purposes of this Act shall have effect as if Chapter 3 of Part 5, Special Rules for Parsi Successions for Interstate, had been removed therefrom. Now, my lords, what is the overall effect of this chapter? Firstly, upon marriage of a Hindu, Buddhist, Sikh, or Jain to a person who, in light of Section 21, is not a member of that faith, you are severed from the joint family. Secondly, my lord, these disabilities under this Caste Disabilities Removal Act, my lord, of 1850 is saved under Section 20. Thirdly, my lords, I am removed from the operation of the Hindu Succession Act if I marry a non-Hindu, and now placed under the Indian Succession Act, as fell from my lords yesterday. But 21A, if we come back to it, it has the effect, firstly, of saying that 19 and 21 will not apply to me if I marry another Hindu. And secondly, it does not apply to non-Hindus, that is, persons of other religions who may marry within their faith. But 19 and 21 apply to those persons.
Ms. Kaju,
My lord.
I think there is one caveat there.
My lord.
Whereas you are right on the first part, the second part will have to be seen loosely, because you are presupposing that there could be other two same-sex couples from the same religion.
My lord.
You have a Christian and a Muslim.
My lord.
Christian and a Parsi, or a Jew and a Muslim, or whatever. So
My
all
lord.
limitations are there,
My
which
lord.
means to that extent you will have to look into the provisions of the Succession Act, concerned provisions of the Succession Act to start with, and other personal laws. Now that is one complication. And the second is, you are very right in straightaway stating that the Hindu Succession Act will apply, or whatever laws of Hindus will apply to same-sex couples who are both Hindus. But that means necessarily, willy-nilly, we will have to interpret. And there, like all of you keep repeating, life doesn't wait. So if there is an unforeseen circumstance like an accident in the absence of a will, or something else, then necessarily the spouse stands excluded. Either Section 8 or the rules of succession of females, or we don't know what other complications are there in other provisions.
And may I say, my lords, perhaps today we cannot know. And we must, I say this with all humility, having considered various aspects of this matter for many years, that all aspects of or questions which may arise before the courts are not clear to us today, as they are not in any case. Your lordships have time and again gone back to the institution of marriage as codified under various statutes and read in various nuances which arose with the passage of time. So as fell from my Lord Justice call, these questions we will be here time and again. But as far as this question which my Lord Justice Bhatt raised, yes, there will be couples who are LGBTQ and my lords who are interfaith couples. And there, my lord, 21A will apply to them as an interfaith couple. And there will be couples, my lord, who are Hindu and LGBTQ. And there, my lords, 21A will apply to them as a Hindu couple. Your lordships are not required today to further read the act beyond reading in and explicating the word spouse.
We look at,
my lords, my
yes,
lord.
Miss Karju,
My lord.
then jurisprudence of this court, which has dealt with provisions of law and their constitutionality, has never isolated one provision. You
My
take
lord.
it to minorities, in the field of education. When an enactment is there, the organic whole has to be seen in the context of a challenge to the concerned provision.
My
Whether
lord.
Old Control Act, which was seen in the 60s, or even Frank Anthony, which examined the entire provisions of the Delhi Education Act to see the impact on one section. So there is an organic whole. So to isolate one would not be in consonance with this the approach of this court, that would be leaving things half done, mostly undone. Therefore, how this has to apply will have to be ultimately taken on by us at one go. That's one way of looking at it. All of you have been consistent saying that these are battles which will be fought later. But that does it absolve us of the duty of constitutional the obligation of seeing and considering doctrinally the impact of one provision over the other or many provisions over one? That you will, that we will have to keep in mind.
My lords.
All of you have given one picture that
My lords.
the rest look at only this, and this is what we want.
May I submit?
Actually articulated the positive and the negative part. So I think it in a way summarizes the entire, let's say, project.
May I say, my lords, that my lord may be right. As a matter of constitutional explication, the constitutional underpinnings must be taken through to their logical end. But my lord, as far as one provision or the other is concerned, I may say that in my own reading of and research into 21A, aside from one judgment before the Honorable Delhi High Court in 84, we did not find any other challenges, my lord, to the constitutionality or otherwise of 21A. I would submit that it poses no problem because it is a part of the seamless whole of the statute as it stands today, in light of the legislative developments that have taken place since 1850. So if my lords will permit, I'll come to my second point, which is on the evolution of the law of special marriage, which commenced, my lord, in 1872. And prior to that, my lord, we would just shortly consider the Caste Disabilities Removal Act of 1850. So if my lord.
You know the questions that we have asking. You just formulate your points.
My lord.
Then what ideas you have,
my lord,
suggestion you have,
my lord,
you can just
my lord, I'm very
away. You will be able to easily appreciate that.
We wanted the other side to begin at 12. Now I think we now start. If we can just formulate, we'll ask the others also to formulate 2 or 3 submissions, and then we just.
I bow down, my lord. So if my lords will just briefly consider, then I'll come straight away to the second portion of my submission on 21A, which is the legislative history of the Act. And I'll quickly take your lordship through it. I won't trouble your lords with my note. In fact, the short point is this. In 1850, my lord, the British legislature introduces the Caste Disabilities Removal Act, which says that notwithstanding any loss of caste, excommunication, etc., the laws relating to property and other benefits which flow from customary law will continue to attract to a person. Thereafter, my lords, comes in 1872 the Special Marriage Act. As a result, my lord, as I understand it, of certain demands by Brahmo Samajis who said at that stage that they were not Hindus. And these were live questions, my lord, before the court as to who was included within a Hindu, within the understanding of the term Hindu, and who was not. And therefore, my lord, when the Act came in 1872, since a need was felt, as is felt today, that no community can be without a law of marriage, this statute required that a person give up their religion, surrender their religion, and therefore it's stated, I've set it out in the tables, that table A, my lord, at page 4, that marriage could be celebrated between persons neither of whom profess the Christian or the Jewish or the Hindu or the Mohammedan or the Parsi or the Buddhist religion, etc. So it required me to renounce my religion. Thereafter, my lord, in 1923, comes Act 30 of 1923, which amended the provisions both as to who could marry under the Act, and secondly, my lord, as to the restrictions on personal law which applied. So, my lord, if my lords see, the first part was retained, that for certain communities, they still had to give up professing their religion. But now, the underlined portion, that marriages could be conducted between Hindus, the Buddhist, Sikh, Jaina, Hindu, so and so, or between persons, each of whom professes one or the other of the following religions. That is the Hindu, Buddhist, Sikh, or Jain religion. And what we must understand, my lord, is at this time, until the coming into force of the Hindu Marriage Act 1955, this would have been the law for any intercaste marriage. Therefore, my lords, it followed, and I'm cognizant of the time, therefore it followed that, as I've set out in the second table, certain restrictions on the application of personal law were imposed, and at this point in time, it was the most onerous. If my lords will see table B, where I have given the provisions of Act 30 of 1923. Firstly, my lord, in 22, as now, it affects severance from the joint family. Secondly, my lord, the Caste Disabilities Removal Act, my lord. Thirdly, my lord, there were provisions that a man could adopt another son, my lord, in section 26. And my lords, under section 25, no person who adopted under this law would have the right of adoption, who married under this law would have the right of adoption. And under section 24, the Indian Succession Act would apply. Next, my lord, came the Special Marriage Act 1954. And this statute, my lord, is also in 54. We are in the middle of the debates about the Hindu Code Bill. And 1955, the Hindu Marriage Act follows. So now, for the first time, there is a unified civil law for the Hindus. There is a unified civil law of marriage for the first time. And under that law, intercaste marriage and intergotra marriage is now permissible. And therefore, the restrictions which are adopted in the application of personal law are modified to those under 1920 and 21, which we have today. In 1976 comes the final Marriage Laws Amendment Act, which brings in the provision of Section 21A, which now exempts those Hindu couples who marry under the statute from the provisions of 19 and 21. What, my lord, does this history tell us? As far as the application of personal law, since it fell from my lords, as far as the application of personal law is concerned, to a couple who marry, who may be LGBTQ, but who marry within their faith, those statutes which are contemplated as applying under Section 21A will continue to apply. That is my submission. Now, what will be the extent of the application? How will those statutes be read? These will be questions, my lord. Courts may hold, my lord, that we are excluded altogether, that there is no provision for the application. But how will those questions arise? In what circumstances, to which persons? Those are, my lords, questions which, as my lord Justice Bhatt perhaps indicated, will arise on a factual basis with the passage of time in different circumstances. But my submission, my lord, would be this, that per se, in my lord's reading of the Special Marriage Act, Section 21A must continue to apply to Hindu LGBTQ couples. There can be no per se exclusion of Hindu couples who choose to remain within their faith for the matter of who they choose to partner with. In 50 years, I would submit, my lords, this section has not created any major difficulty with respect to its interpretation to opposite sex couples. And my next submission is this: my lords should not presume and pre-anticipate a difficulty which would arise for LGBTQ couples. On the one hand, the union submits that it would play same-sex marriage or LGBTQ marriage would play havoc with personal law. On the other hand, we tell your lordships that we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying, from a series of cases in Lata Singh's onwards, that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples, as today they protect us when we approach the courts. And the state also responds by offering, for instance, under the Dr. Ambedkar scheme, under the Ministry of Social Justice and Empowerment, special schemes to promote intercaste marriage. So, my lord, it cannot be presumed, because today we are going through a process of social change, because today we are at the threshold. Neither this court, nor I would humbly submit the state, should presume that there is going to be a certain kind of outcome. They should see their people. It is not only a question of elites, my lord. We receive calls and we hear from young people across this country. From the inception of this case, my lord, I've received calls from people in Hisar, in Surat, in Chhattisgarh. When I asked, which district are you from? They said, which district? We are from Raipur, we are from Rajnandgaon, you name it. Let us not assume any more than we would assume at the outset of embracing any section of our society within the fold of law. Let us welcome them. Let the union welcome us and bless us as it would bless any other married couple, my lords. We seek those blessings. So, my lord, my last submission, therefore, is this, and now I promise I will wrap up, is that when it comes, therefore, after we marry, to the application of laws must be uniform for both same-sex and opposite-sex couples. On the one hand, my lord, there are general civil laws, for example, as fell from my lord the Chief Justice yesterday, of gratuity, pension, inheritance, succession, and so on. And my lords, those laws, the word spouse would be read in, the word husband or wife would be interpreted in a gender neutral fashion. And my lords, where a person would otherwise nominate their spouse of the opposite gender, today we would be nominated as spouses of the same gender. The other question, my lord, is the question of having children. Now, it fell from my lords, and very rightly, my learned friend, Mr. Vishwanathan, also said that today, perhaps not all couples wish to procreate. Not all couples who marry shall have children, and nor is having children a condition of any law. But my lord, as a couple, as a married couple, having a child is part of the human experience. And it may be something that some also long for. Today, marriage is a gateway for couples to have children as per the legal framework. So under, my lord, the JJ Act, the adoption regulations require that a couple have been married for a certain number of years, that there be a stable marital relationship and so on. This is, my lord, for a couple to adopt. Now, my lord, similarly, under the Surrogacy Act, only married couples may opt for surrogacy with some provisions. And the child who is born of surrogacy is protected under Section 8 in the same way as a child who is born of, let us call it, natural methods or a natural born child. Similarly, my lord, the adoption statutes say that at the moment of adoption, an adopted child, there will be a severance with the biological family, and the adopted child will have all rights and obligations as a biological child does. Now, what is the import of what I'm saying, my lords? There are already couples in this country who have children, LGBTQ couples, and those couples are also before your lordship. In the absence of the recognition of marriage of their parents, what the law does is it renders, just as it renders one partner of the relationship a stranger to the other, it also renders a child a stranger to its parent-in-law. That child has no relationship in law with one of its mothers who may love her equally as a mother in an opposite sex couple, who may do everything from morning to night as a mother does in an opposite sex relationship. But that child, my lord, without the protection of law, without the protection of adoption law, or the provisions of Section 8 of the Surrogacy Act, or similar provisions of the Assisted Reproductive Technologies Act, is rendered a stranger to its parents. That, your lordships have held on numerous occasions, is constitutionally untenable. A child cannot suffer because of the parents belonging to a protected class under Article 15. This is the sum and substance of my submissions, my lord. I'm grateful for a very patient hearing to this side. I'm obliged.
Now, we now have four remaining counsel, Mr. Raghav Avasthi, Mr. Shivam Singh, Mr. Namit Saxena, and Mr. Manu Srinath. We would request all four of you to now wrap up in 2 minutes or 3.
Your Lordship, Ms. Amritananda Chakravarti. Your Lordship, I'm a petitioner just after Ms. Karju.
Yes.
Yeah, I'll just take 10 minutes, Your Lordship. Very brief. I've already given my note, my lords. It's volume 8. It's a brief 1.5-page note, Your Lordship. I've set out my...
Got your note. If you can just make maybe 1 or 2 points now.
Yes, Your Lordship.
What is the...
Your Lordship, I have challenged certain provisions of the Foreign Marriage Act and the adoption regulations. I'm the only petition that has challenged the adoption regulations for excluding same-gender couples and transgender persons from the institution of adoption, joint adoption specifically. Why have I challenged adoption regulations? Before that, Your Lordship, I just want to say that the petitioners, they have been in a relationship for the last 15 years, and they have married under the Denmark law on 16th of August 2022. So we are a couple who is married under a foreign law, and we are living as a married couple in Germany. And what we want, we are there because of our professional deputation. We don't want to settle abroad. We want to come and settle in India, but we want with our marital status, we want with our joint life that we have built in Germany. So the question on Foreign Marriage Act, I just have one point, Your Lordship. Your Lordship has my note?
Yes. Why don't you formulate it?
Yes. My first submission under the Foreign Marriage Act, Your Lordship, is if not for my sexual orientation, the petitioners would be able to register their marriage in India under Section 17 of the Foreign Marriage Act. And what is that exclusion, Your Lordship? That is not, if I may respectfully submit, under inclusion, Your Lordship, that is discrimination simpliciter. To exclude a couple on the ground of sexual orientation, that you are treated as a married couple in Germany and in yes. So that is discrimination simpliciter. My second point on adoption regulations. Your Lordship, I've set out the adoption regulations in my note.
Yes.
B. If I may read, Your Lordship.
What's the point on the adoption regulation?
That my point is the adoption regulations go beyond the remit of the Juvenile Justice Act. If I look at Juvenile Justice Act, Your Lordship, the definition of prospective parents in 249 of the JJ Act, it uses the word person or persons. Your Lordship, if you may look at the JJ Act just for 1 second. 249, Your Lordship. My Lords, Justice Kaul and Justice Bhatt has it. The JJ Act 249, the definition, if I may read.
Yes, read please.
Prospective adoptive parents means a person or persons eligible to adopt a child as per the provisions of the Section 57. Please mark these words, Your Lordship, a person or persons. Now, if I may come to Section 57. Your Lordship, please note JJ Act is a secular legislation that has been said by my learned predecessors. This is not, I'm getting into personal laws. This is the only law which we had brought in adoption from the Hindu personal law into a secular legal regime. Your Lordship, if I may read Section 57, Clause 1. The prospective adoptive parents shall be physically fit, financially sound, mentally alert, and highly motivated to adopt a child for providing a good upbringing to him. Clause 2. This is the relevant clause, Your Lordship. In case of a couple, the consent of both the spouses for the adoption shall be required. Then 3 is a single or divorced person can also adopt, subject to the adoption regulations. 4, single male is not eligible. That's not relevant. I am on 57.2. My first submission, Your Lordship. Marital status of a prospective adoptive parent is not a relevant factor to determine the eligibility of adoptive parents, including for joint adoption, which is my Roman 3 in my note. If we look, as we had seen, the definition of prospective adoptive parents, or Section 57.2, where is the word married here? If the parliament wanted to restrict joint adoption only to heterosexual married couples, because married is not just married couple. As of today, as we have seen in the last 2 weeks, it is heterosexual married couples. Which couple can marry under the Indian law at present? If the parliament wanted to restrict joint adoption under the JJ Act Section 57, it would have used the word married. But it doesn't. It uses the word couple. It uses the word spouses. Yes, it may be said that as per the Indian law, couple and the spouses is a heterosexual married couple. But that is not what the legislation says. So how can the adoption regulations... Now, if I may read adoption regulations, Your Lordship, Regulation 52A, which I have challenged, any prospective adoptive parent, it is set out in my note point B, irrespective of his marital status and whether or not he has his own biological son or daughter, can adopt a child subject to the following, namely A, the consent of both the spouses for the adoption shall be required in case of a married couple. Regulation 5.3, no child shall be given in adoption to a couple unless they have at least 2 years of stable married relationship. Where is this word marriage in the JJ Act, Your Lordship? And even Your Lordship has held, Chief Justice Justice Chandrachud, in X versus Ministry of Health, marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. Your Lordship, I will not take you to the judgment. It is in the common compilation. But I am emphasizing on this phrase in para 40 of the judgment, X versus Ministry of Health. Marriage is not a precondition. So it means even this principle has to be applicable to the point of joint adoption also. Marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. I'm emphasizing in or in relation to one another. Just take the example of the petitioners, Your Lordship. I am a married couple in Denmark. I come to India. My marriage is not recognized. I am dealt as two single individuals who are stranger to law. I cannot even go for joint adoption because of this regulation, which is not borne out from the text of the law. My next submission, Your Lordship, is restricting joint adoption only to heterosexual married couples amounts to discrimination on the ground of sexual orientation. Why am I saying this? Because one can say that, yes, even unmarried heterosexual couples can also not adopt jointly. But they have the option to marry under the Indian law. But a same gender couple or couple involving a transgender person, they do not have the option to marry. So in effect, what the adoption regulation is doing, it is essentially restricting joint adoption only to heterosexual married couples. And that, in my humble submission, is discrimination on the ground of sexual orientation. And I will show Your Lordship from the CARA circular, which is on, if Your Lordship, compilation 2 documents, volume 2, if Your Lordship want to look at it, that is a circular dated 16th of June, 2022. And I will show how that circular even bars me in my individual capacity. That is in compilation 2 documents, PDF, volume 2, PDF 459, sorry. Your Lordship may please look at it. Compilation 2, documents, volume 2, PDF 459. Just one document I want to show Your Lordship. It's a CARA circular dated 16th of June 2022. And that will show the sheer absurdity, because it fell from the Lordship last week that a lesbian woman can adopt in her single capacity. Okay, you might not be able to adopt in your joint capacity, but you can adopt as a single person. Now, I will show. Your Lordship has it, the circular? Volume 2 in documents, compilation 2, volume 2, documents, page 459, PDF page 459. Justice Bhatt and Justice Kaul has it?
Yes. Read
Your
it
Lordship,
here.
if I may read, just 3 lines. It's an office memorandum from Central Adoption and Resource Authority. Registration of cases of single PAPs, prospective adoptive parents, that is, having a live-in partner in a long-time relationship and not married regarding. It has been noticed from home study reports that some single PAPs registered with CARA for the adoption process are in relationship with their live-in partner. The cases of single PAPs engaged in live-in relationship have been discussed in the steering committee of Central Adoption Resource Authority held on 18th April 2022. It has been decided to go with the earlier decision of 14th, I'm not reading that, then after 10th May 2018, that the cases of single PAP in a live-in relationship with a partner will not be considered eligible to adopt a child, and their registration from concerned agencies, authorities will not be considered for approval. Then point 3, this is the main line. The decision has been taken in line with Regulation 5.3 of the Adoption Regulation 2017, which is exactly the Adoption Regulation of 2022, 5.3. The authority would like the children to be placed only with the stable family, and single applicant in a live-in relationship cannot be considered as stable family. Your Lordship, this is the Kara circular, which is barring even a single person who is in a live-in relationship from being eligible to adopt a child. All this while we have been thinking that a single person, a single queer person, a single lesbian person can adopt in their single capacity. What is the harm? You have access to adoption. But I don't. And where is this coming from? It is referring to Regulation 5.3. So just look at my state. I am married in Germany. I come to India. I am treated as a stranger in law to each other. And now I cannot even adopt in my single capacity because I am in a relationship with my partner. I am, in fact, a married couple as per foreign law. So as per the Indian law, as per the adoption regulations, I am not even thought fit to be eligible to apply in my single capacity. What is the effect and what is the messaging to the queer community? Your Lordship, my last point. My predecessors have talked about right to found a family. I'm saying right to motherhood. I'm a lesbian couple. I have been desiring to have a child, to adopt a child, as much as I desire to have my relationship recognized. Now, last point, Your Lordship, it is not just the right of a adoptive couple to a family. It is also the right of a child to a family. We are talking of adoption, and as per the JJ Act, who is to be adopted? If we look at section 56 of this right has been statutorily recognized. If I may read, Your Lordship, section 56(1), adoption shall be resorted to for ensuring right to family for the orphan, abandoned, and surrendered children. These are the children we are talking, Your Lordship, orphan, abandoned, and surrendered. And they have a right to family, not just under the JJ Act, under the international law also, under Convention on Rights of Child, Article 20. The exclusion of same-gender couples and transgender persons from adoption defeats the very purpose of adoption, defeats the very essence and the object of adoption, which is what? Which is to provide a stable, a loving and affectionate family to a child. Just because I am part of a same-gender couple, just because of my sexual orientation, I will be denied this basic right, not just to myself, but even to a child who needs a loving family. And lastly, what Ms. Karju said, Your Lordship, the entire JJ Act, what is the guidance of this JJ Act? It is in the best interest of the child. Is it in the best interest of a child not to have a legal relationship with the second parent? Is this how we are going to advance the object and the purpose of the JJ Act? I rest my case, Your Lordship, with just last point that the petitioners, they are part of a historically oppressed and discriminated minority. Their relationship and their family deserve as much dignity and recognition as it is to be accorded to an opposite sex couple. I'm really grateful, Your Lordship. I'm really grateful.
Now,
please, this honorable court, Your Lordship, and your ladyship. Yes. My lord, I'm appearing through video conferencing, and as a matter of fact, I happen to be in Germany, and my marriage was also registered in Denmark. My petition is in relation to, it seeks a declaration in relation to Section 5 of the Hindu Marriage Act, and it has already fallen from your lords that there will be no interference with personal law, but let me at least make an elevator pitch because I have only 5 minutes either which way. So I cannot expend more than 5 minutes of the Constitution bench.
But Mr. Avasthi, I think this area we have, nobody has opened. So, for us to open it in 5 minutes would be unfair because, this is an area which we have scrupulously excluded from the scope of the debate. Once we open this up in 5 minutes, it would be unfair, having regard to the canvas of the matter. And nobody else, everybody else would like to then argue the same point, I think.
My lord, I bow down. As a matter of fact, just one moment, my lord, then I leave it up to this bench. My submission only is that as per Section 4, as far as the matters with respect to which provision is made under the Hindu Marriage Act is concerned, there is no interference of any customary religious authority. And my second point is that as per Section 7 of the Act, there is no religious ceremony mandated as such. So if we were to say that if I were to be a straight, should there be a straight couple, then what we are saying is that their faith in the ceremony that they want to adopt would be enough to get their marriage to be valid under the Hindu Marriage Act, while not extending the same courtesy to a same-sex couple. So this is my submission, my lord, and to my mind, it is a violation of Article 14 of the Constitution. And because as I mentioned, as per the Act,
Awasthi, I
there is
think
no
we'll leave
religious
it at
ceremony.
that because I think
My
we
lord.
shouldn't really explore this any further. I think because this is now out of tune with what is the general line of submissions, the area which has been opened before the court. I think we'll leave it at that for the present. I think.
My lord, much
Thank you. Now the next counsel would be Mr. Shivam Singh.
Yes, Your Lordships. Extremely grateful for the opportunity to address Your Lordships. I'll restrict my submissions in 5 minutes. My argument relates mostly to the idea of innateness, and I'll build upon the proposition which has been culled out in para 278.7 of the Navtej Johar judgment, Your Lordships. The argument about innateness, and this has briefly been alluded to by my predecessors, particularly Dr. Singhvi, is that if something is so innate to a person, then it is impermissible and, for that matter, even unconstitutional for the state to utilize that as an opportunity and as a yardstick to impose and discriminate against the person. Sexual orientation is one such category, as has been recognized in the cited paragraph of Navtej Johar. Your Lordship, in this regard, let me just build this by an example. When a person is born, that person, while growing up, will either choose to be right-handed or will choose to be left-handed. Subsequently, through a process of choice, that person can even change whether to be right-handed or left-handed. A person can be ambidextrous. These are the spectrum when we are talking about gender and sexuality. A person can move from one to the other, can be both, can be none. So these are the parameters on which this moves. Now, sexual orientation and gender, as has been recognized in the cited paragraph, is such an innate characteristic of a person that to discriminate on the basis of that would fall the test of constitutionality. And I say this for a particular reason, Your Lordships. It is not open for the state government to discriminate, or for that matter, the union government to discriminate on these parameters. If they were to do so by using a person's sexual orientation against them, something in most cases people have no control over, then without establishing as to what is the harm which is being caused to any other person, it would fall foul on first principles with the social harm, Your Lordships. There is no harm which is being caused to anyone in this regard.
From that, what is the submission?
Your Lordship, the continuation of this is that the grant and conferral of these positive rights upon the queer community is not a zero-sum game. It is not being granted to the queer community at the expense of anybody else on the other side. The only argument which the union, or for that matter, the state government can present is that this is running contrary to the idea of social morality, of public morality, and that is the basis for them to deny this right and to deny this privilege. In this regard, Your Lordships, let me just build the argument as to why it would be completely impermissible to do it. Their argument about social morality and public morality rests in an amorphous contour which they are yet to define through their counter affidavit. Their counter affidavit, however, proceeds on a slightly hurtful, if I may say so, presumption, which is available in para 36 at page 45 of their counter affidavit, wherein they say that only one form of protection, or only the highest form of protection, is available to marriages of the opposite sex. Merely because that has been the case so far is no reason for the union government today to argue that it must also be the case going forward. They have to demonstrate as to how the conferral of these rights would dilute or snatch away the already vested rights. And Your Lordships, in continuation of this, I would just, as a matter of abundant caution, Your Lordships have already indicated on day 2 that probably this is not an argument to belabor upon. on the concurrent list aspect. This is a part of entry 5, Your Lordships. Previous hearings have indicated that whether hearings have taken place on arbitration entry 13 or IBC entry 9, it is not a case where all state governments must mandatorily first formally be issued notice and then they come. State governments are already here. The union has already invited them. They'll assist Your Lordships. The law which Your Lordships will lay down under 141, one way or the other, whether for us or against us, will be binding upon them in terms of the meaning of Article 144. So it will not be open to them to say that merely because we were not formally impleaded as parties, we will escape the rigors of this law one way or the other. And to conclude, Your Lordships, I'll just make the submission. Your Lordships, it is part of the basic structure that secularism in India has progressed and thrived and endured because it is founded on the concept of Sarv Dharm Sambhav. Your Lordship, through the building blocks of Navtej Johar, Joseph Shine, Babita Punya, and now Supriya Chakravarti, it is time for the concept of Indian marriages to endure by embracing the concept of Sarva Linga Sambhav. I'm extremely grateful for a patient hearing.
Thank you, Mr. Shyam. Mr. Namit Saxena.
Mr. Saxena is not available. He's not well today. So we have submitted a one-page
All right, we'll look
Let
at
that be
this.
considered.
Yes, Mr. Manu Srinath.
Well, I have prepared a one-page formulation. If I could just hand over. I will
Yes, sure.
mail the soft copy.
So this is the one.
There are 4 major contentions, my lord, which I have taken. I would not repeat these arguments orally. The judgments as well as the paragraphs which I am referring to are mentioned there. The written submissions, my lord, would find it at page number 605 of the compilation 1. Those arguments are dealt with extensively. So I would not repeat these arguments again here orally. My lord may consider my written submissions. The 4 major the arguments taken, my lord, are that exercise of judicial review would become a duty for this constitutional court and would also become a matter of entitlement for persons when fundamental rights are violated. That it is the court's duty to do an organic construction of ordinary laws of the land as well as that of the constitution. And the exercise of judicial review to achieve social justice should also be there. Finally, my lord, the exercise of judicial review leading to an increase in size of the intended pool of beneficiaries of a statute, my lord, is permissible, and such an exercise will not amount to legislation by courts. I've cited the examples of Geeta Hariharan, D.S. Nakara, my lord, as well as Secretary Mahatma Gandhi Mission, which is 2017 SAC.
All right. Thank you. Thank you so much. Brother Call, should we take just a 5-minute break? That will also give the, then we can start with the submissions of the Solicitor General.
My lord, there are 3 interveners in the matter. And in my case, my lord, it's a very practical point that I wish to highlight. My case is that of a trans woman who converted to a woman after undergoing sexual reassignment surgery. Now, this is a woman who has all her life lived and dressed like a woman. She's part of the Bollywood industry as well, my lords. After undergoing sex reassignment surgery, she married a male, a biological male, my lords, under Hindu rites and ceremonies. Thereafter, my lords, she has registered her marriage under SMA. All this has happened before the Transgender Persons Act came into force under the strength of NALSA, my lords. There are 3 or 4 litigations which are pending between her and her husband right now, including one litigation under Domestic Violence Act. There is one FIR under 498A 406. There is a suit pending for dissolution of marriage under Section 13 HMA. My lords, there is one submission that I want to make, rather, in fact, 2 very short submissions here, because I believe that the judgment of this Honorable Court may directly have an impact on my ongoing litigations, my lords. My lords, HMA per se does not prohibit these kind of marriages, my lords. It neither renders this kind of marriage void nor voidable. And I'll quickly demonstrate that by reference to Section 5, my lords, if my lords could quickly have that, my lords.
Which act? Hindu Marriage Act.
Hindu Marriage Act, my lords.
Counsel, there is one concern here.
I don't think we'll go into this at all because we've consistently said.
My lord,
first
I
laws we'll
understand,
get
but this is a case of not of same-sex marriage, my lord. This is a case where she has undergone the sex reassignment surgery.
deal with individual cases like this, because
my
otherwise there'll
lord,
be infinite variations in individual cases.
my lords, the practical difficulty here is
But
that
ultimately, that's why you're an intervener. We can't now sit down and look at interveners' facts and deciding a wider issue of constitutional jurisprudence.
My lords, I completely appreciate that. But my lord, just for a moment, if I could point out the contravention of section 5(1) subclause 3,
See, this
which
is
is
all going to be case specific. And if we get into specifics of each case, then there's a Pandora box that'll open up. We can't go that.
then, my lords, what I may submit, I'm not referring to personal law, let me submit this. As per the Transgender Persons Act, now there are two categories which are recognized by the Act itself. One is a transgender person. The recognition given under law is that of transgender person. The second category under Section 7, my lords, is that of recognition as male or female. Now, once I've undergone the sex reassignment surgery, or those persons who may be called as transformed gender persons, my lords, because now they are conforming to the biological yardstick as well. So they may be entitled to equal protection under the law. So that impact, my lord, may consider while passing the judgment.
Gupta, what?
Yes, my lord, 7 minutes. I will be less than that. My lord, I appear for, my lord, the queer collective of, my lord, the Indian Institute of Science, which is a protective body, my lord. Now, we have, my lord, our submissions are in volume 9 of your lordship's, my lord, compilations. And, my lord, a one-page note has been emailed today, my lord. You have copies? My lord, I can hand up 3 copies if your lordship so pleases now. I will only, my lord, address your lordship on 5 issues and I'll just state them. I won't argue, my lord. My lord, I have thought about this matter, my lord, on the basis of 2 questions: why and how. Why it is to be done and how it can be done. My lord, most of the submissions, 4 of these are, my lord, points on the issue of why. My lord, first of all, my lord, section 4C of the Special Marriage Act appears to make a distinction between men and women as far as age is concerned. But this is no longer, my lord, a policy consideration, because, my lord, pursuant to your lordship's judgment in independent thought, the Child Marriage Bill has already been tabled, which, my lord, seeks to equalize the marriage age for men and women. So, my lord, there is a consensus that on the appropriate age of marriage. So the difference between these 2 categories, my lord, in the section is not a matter which should come in the way. That's number 1. Number 2, and this is very important, my lord, that persons of this, my lord, sexual orientation are being forced into marriages. And what is worse, my lord, heterosexual marriages. And what is worse, my lord, there are unscrupulous people out there who are suggesting that there can be conversion therapies, that it is medically capable of being corrected. Now, my lord, it has gone to such an extent, my lord, and I have got, my lord, a 1-page, my lord, opinion of the Indian Association of Clinical Psychologists, which I am handing up, my lord, where they have said that please do not get into, my lord, this question of conversion therapies. My lord, the point being, my lord, that if they are permitted to marry, they will be protected, my lord, against any forced marriages of the heterosexual nature, and they will not be subjected to any conversion therapies, my lord. So this is, my lord, a reason why. Thirdly, my lord, it is a misconception to say that family values that Indians cherish will be affected. Because, my lord, it is precisely for those so that they may enjoy and practice those family values that they wish to get married. All the values which we cherish as being, my lord, family values are, my lord, going to come into effect if they are permitted to marry, my lord. That's the third thing. The fourth aspect, my lord, is, of course, your lordship has heard it at length, and that is, my lord, that it is discriminatory per se to have a legislation which makes a distinction. Now, on that, my lord, in my note, and I'm not troubling your lordships further, paragraph 20 refers to, my lord, 2 judgments, one of South Africa and the other is of Canada, which says so, my lord, that If there is a legislation of relating to marriage, and that legislation is discriminatory in the sense that it leaves out same-sex marriages, then I'm sorry, my lord, if it leaves out same-sex marriages, then it is discriminatory. Now, my lord, I come to the fifth aspect, my lord, that if the question of why is answered in favor of the petitioners, in that event, my lord, in order to prevent the invalidation of the legislation, my lord, it would be necessary to read it purposively. And my lord, your lordships have already said that could involve adding, omitting, or substituting words, and that is AFCON's, my lord. My lord, those are my submissions.
Thank you, Mr. Gupta.
I just need 1 minute.
May it please the court, my lord. I think I come next in the order of the sequence that is
sorry.
given to your lordships. If the sequence is being followed.
It's to address the
Tulsi Raj, Ms. Tulsi Raj.
Yes, I am. Yes.
Please.
Also,
Obligation. I've prepared a brief note, my lord. I'll hand over a copy. Without repeating any of the points that's been already made, my lords, I think only two aspects of anti-discrimination theory that remained unexplored so far in the debates. The first aspect is, my lord, the concept of demeaning, which has been conceptualized by the scholar Deborah Hellman, and which your lordships will find on pages 3297 of volume 4 of the compilation on behalf of the petitioners. Ms. Hellman explains that every case of demeaning, my lords, every case of disrespect does not constitute wrongful discrimination. Scholars, my lord, your lordships are well aware, have always asked the question of what is in fact necessary in law for some act to be constituted wrongful discrimination. And she identifies two elements as important for an act to be identified as wrongful discrimination. The first is, my lord, that there should be an expression of unequal humanity of the other, that there should be an action that reflects that the other person is not treated as an equal moral person, and that is the first requirement. The second is that, my lord, the person who is discriminating, the discriminator, should be able to do that because of the social context. That is why, my lord, your lordships are aware, we have the whole concept of cognate and dominant groups in discrimination law, and it's always conceived that it is always a dominant group who is able to, or who is conceived by law to be able to discriminate against a cognate group because of the particular social context. Now, in this case, I would submit, my lord, that the exclusion of LGBTQ persons from the ambit of the Special Marriage Act would constitute demeaning in the way that scholar Hellman explains it. This is because, my lord, there cannot be a better example of demeaning rather than to say, my lord, that your love is incapable of being recognized by the law. There is no, my lord, no better example of demeaning rather than to say that your partnership is not deserving of legal recognition. Therefore, my lord, I would submit that the scholarly understanding of discrimination law, my lord, might help us to inform the reading of Articles 14 and 15, to inform our reading of the Equality Code of the Constitution. Now, the next point, my lord, is by referring to the theory of disgust by Martha Nussbaum, and your lordships have extensively made use of the scholarly literature by Nussbaum in various judgments. Now, my lord, the theory of disgust is propounded in the way that the approach towards same-sex couples, or the approach towards LGBTQ in toto, is grounded on a public disapproval, is grounded on certain prejudicial understandings of how these couples or how these persons conduct their lives. Now, lordships will certainly appreciate, my lord, that the history of this is tracked, in fact, by Nussbaum in the American context by collecting statistical data relating to pamphlets which were spread during the whole debate on.
We'll have a look at that.
Yes, my lord.
Be circulated. Then your next point is expressive harm and discrimination, which is based on Joseph Shine.
Which is based on Joseph Shine, my lord. I just want to make the point there, my lord, that when your lordships, my lord, struck down section 497 of the IPC, my lord, there was nothing in the provision expressly as it stood, my lord, which expressed any opinion about how what it conceives about the sexuality of women. But your lordships went ahead and said that there are certain prejudicial notions which inform this provision, and that is sufficient, and that prejudice is sufficient to render this provision unconstitutional.
The next point is about the proportionality test, which has been argued actually. Just yesterday it was cited.
Yes, my lord, the proportionality.
That's all right. You
Yes.
cited modern day.
Yes, my lord, your lordships have dealt with proportionality, my lord. And
then fourth is that your case is supported by data and that the respondents is.
yes, no, because, my lord, in paragraph 18 of the counter affidavit, my lord, the union says that there are psychological harms which are caused to the children of LGBT. That, my lord, is in fact rebutted continuously by data, my lord. And I have referred to one study, that is a British Medical Journal study,
And
on
the last
pages
point is
3341 and 3358.
You are advocating a moderate interpretation, reading A as the in the SMA.
Yes, my lord. That is, in fact, a lot of suggestions have been put forward before your lordships, my lord, and it is, of course, up to your lords as to which interpretation will be taken, and that's a moderate and a minimally invasive provision.
Thank you.
I'm obliged.
My lords, if I may, I only wish to address.
What's your name?
My name is Tanushri Balla. I'm an intervener.
क्या नाम है? Manjushri Balla. Tanushri.
Yes. Sir, I only request to address the 4 questions placed by this honorable court before the petitioners.
Yes.
Your permission, please. Sir, I've submitted my written submissions and a brief note. If I may hand the same over to the bar, please. Bar, please.
So we also do have this. It's being given physically to the.
Yes. Yes, my lord. Sir, the first question, Your Lordship, the first question addressed was on section 2B as to the reading of the terms man and woman. My only request is that it may be considered that there is also gender expression amongst parties who are seeking this kind of validation. There is gender expression, and then there is also the question of roles that may be assumed by parties to such marriage. If this concept, read in light of Arun Kumar and certain other data which I have put on record in my main IA, be taken into consideration, my lords, we may see that basically the problem in all the other sections remains solved. My humble suggestions are, my lords, that the man in 2B be read to include all 3, that is both cisgendered and transgendered men, as well as any person who assumes a role in the marriage that this statute confers upon men. And similarly for women, all 3, that is cisgendered, transgendered, and any person of either sex or gender assuming the role of a woman or a wife in that particular relationship may be conferred upon by the statute or by the society or by the institution of marriage. This will also remove the difficulty for trans persons, intersex persons who are not included in this ambit seeking to enter the institution of marriage laws. Accordingly, lists of prohibited relationships in part 1 and part 2 may be read to include any person, whether cis, trans, or otherwise, including but not limited to those identifying as third gender, so that both lists may apply uniformly and the difficulty with related to degrees of prohibited relationships may be removed. Thirdly, my lords may be pleased to direct the government to declare LGBTQI, which has already been done for the trans community, as a special class, as they are allowed to do so for customs, so that where personal customs of parties allow them to get married and enter such institution, there may be no difficulty for them to do so. We are not touching upon personal customs, but where they are allowed by personal customs, where families are supportive, they should not be hindered just on basis of a technicality. My lords, my second point, with your permission, is section 4C, which was the consequence of section 2B, as pointed out by Honorable Justice Butt, that it has already been pointed out by learned senior Vishwanathan sir that the section may confer 2 males and 2 females of age 21 and 18 respectively to enter matrimony. However, what I request to add, sir, is that this provision leaves out third gender persons who may be intersex persons and who may be left out of the binary of male and female. For that, I request, my lords, kindly read an age into the section for third gender persons not conforming to either male, female, or the role of a man or woman based on self-identification, such as intersex persons. So, and also any other affected person on the remaining spectrum may be addressed by this particular reading in. This may also be relied upon Section 15D of the Act, my lords, where the age is uniform for any parties as 21 seeking to register their marriage among within the Act, without leaving any lacuna for external controversy or any external violations. My lords, my next point, which is extremely important and which I request to add before this honorable court, is based on Section 24(2). My lords, this is the section for void marriages on grounds of impotence. Now, in practical cases, it has been seen that unscrupulous people enter into such marriage with trans persons, and when disputes arise, as in the case of intervener Bobby Darling, they seek the shelter of law, stating that the marriage was void ab initio because of the ground of impotence, or that they did not know. Herein, if my lords may please to declare or add as an explanation in any way that these marriages would be void except when knowledge of such impotence was communicated prior to the marriage uh, to both the parties by either a visibly obvious way or in an express manner, basically prior to the marriage, or where the parties, after discovery of such fact, have continued to cohabit, condone, and live with each other in harmony for at least 1 year after the discovery, then this particular law, which is being misused by unscrupulous persons, can be addressed, and this will greatly reduce litigation, my laws, current litigation.
All right.
And my laws, lastly, I will just conclude in under 1 minute. If we read gender expressions and accept the roles assumed by parties into this act during interpretation and harmonious interpretation, my laws, all the remaining sections and all the remaining difficulties will stand resolved, as in 3rd, 4th, and 5th schedules. It's on para 6 of my brief notes, my laws, wherein declaration may be by either 2 brides or wives, or 2 bridegrooms or husbands, or a bride and a bridegroom of either biological sex expressing or assuming the role as per the marriage. Sections 12, 22, and 27, where it mentions either husband or wife, it does not mandate.
All right, we'll have a look at
That's
it. Thank you.
Thank you, my
Thank
lords.
you very much. We'll rise, I think, now, because we have reached 5 minutes. Mr. Solicitor, we'll hear you after lunch.
Look, there was a matter, but wherein 80 by 3 had said that she may join.